Yes, Counsel. Good morning.
Good morning, Your Honor. If it please the Court, Donna Patalano on behalf of the Commonwealth. This is a pretty straightforward case of whether or not the judge had authority to dismiss a case because of a lack of probable cause.
What do you say was the probable cause?
I think there are 7 things that go into the probable cause here. The first thing is the quantity. While it's not a lot, it is packaged, and when you take it with the other factors, it's significant. There's the smell.
There are 5 individually wrapped bags.
Yes, Your Honor. But I think when you take it along with the location, the time of day, it is important. If I can just say, the location is the school. This juvenile comes into school late during the day with no smoking paraphernalia, which is incredibly significant here.
But there's an odor of marijuana on him.
It's not clear whether it's burnt or unburnt, Your Honor.
Problem is that.
Well, if it's probable cause to arrest, I don't think there's a problem at all with that.
No, in
That's the
terms of
standard that we're
determining, you say
dealing
it's
with.
unclear. Why can't we assume that it was the odor of smoked marijuana?
Well, even if you decide to go with the draw the inference that it's smoked marijuana, which is not clear in the record, the location and the time is significant here.
How was the time significant?
It's 9:30 in the morning, Your Honor. He's coming to school late, and the fact that I think that he basically is a businessman, you can make an inference that he is
How
coming.
do we know he's a businessman?
That he's coming with what would be his volume of sales for the day to sell.
Well,
And
how do we know sales?
because he doesn't have any paraphernalia to smoke. And that's significant here, too, because if he were going to smoke this marijuana, why would he be coming into the school at 9:30 in the morning with nothing to be able to use
He already
this?
smoked his marijuana before coming to school, and he wanted to have his supply with him.
Well, the supply would be of no relevance to him because he has nothing to smoke it with. So I think the likely inference that could be, the inference that should be drawn is that he's going to school where his client base is to sell his volume for the day. And that is significant that he has no cash with him, the location, the time. Again, it isn't clear that it's...
If he had cash with him, you would say that was significant. So what?
Right, in order to give change to the people who are buying.
No cash, and that was significant.
Well, I think you can draw inferences from it, Your Honor, and maybe that's not compelling in this instance. But the fact that he has no smoking paraphernalia is compelling. And I will say that, you know, we're not at the level where we need to determine sufficiency here. This is probable cause to arrest. It's an extremely low threshold. And intent is always the most difficult element to prove. But you can draw a reasonable inference here that he had the intent to distribute by the time of day. And that's not even talking about what his agitation is. And I think based on his agitation, that you might actually draw the inference that it is unburnt marijuana that's smelled. Certainly, if he came in after just smoking marijuana, it'd be hard to, you know, you could draw an inference that it'd be less likely that he'd be agitated.
Does the record reflect the weight?
No, it doesn't, Your Honor.
So we have no clue whether this is as to the size of these packages.
No, we don't, Your Honor.
And
we don't know
would
if
that
it's-
not matter?
I could
claim
go,
of
that
distribution?
could go either way, but when the evidence is in equipoise, I think we get the benefit of that in the
that's a-
determination of probable cause.
The amount that is subject to civil infraction would have to be a lot of baggies or a really big one, and you wouldn't be saying little baggies or whatever the inference was you could stuff in a pair of shorts.
Right.
So I think the inference here is clearly small amounts. In his shorts, inside his pants, nobody's saying big. I mean, how much does it look like if you have an ounce? Quite a pretty big amount, right? So what's to distinguish this from any other person who's carrying a civil infraction amount? Anything? I mean, I'm trying to look at our decisions. Looks like they would all be subject to PC determinations if, under your formulation.
It could
Almost
be.
no one would not be.
Well, not necessarily, Your Honor. The timing is significant, that he's coming in at 9:30. If he's going to use this for personal use, why does he come to the school to smoke? Why not just stay out of school? He's already indicated that he's willing to be late for school. Why not just stay out to smoke it if it's for personal use?
He got a good deal on the way and smoked one of the bags, and that's why he's late.
Again, Your Honor, that's an inference that could be drawn, except that, again, we don't know whether or not it's burnt or unburnt marijuana, and that's something that would come up at trial. But
The problem with the inferences is that you could really make them any time of the day. It's morning is good, afternoon would be great, late night would be also good, money, no money.
well, that's why, Your Honor, the level of probable cause at this determination is quite low. It's the level to arrest. We're not at trial here. And at trial, there's a lot more evidence that we could bring in.
Did the judge see the 5 bags? We can assume that, can't we?
It's unclear from the record, Your Honor, whether or not the judge saw that, and I don't know. It could be that he just determined the complaint based on the 5 corners of the application, which would be the appropriate thing to do under the rules, which would be the police report.
Now, let's assume you had a situation in which there plainly was not probable cause. With regard at least to a juvenile, where the arraignment matters in terms of the record, why would a judge not be able to postpone the arraignment and essentially hear the motion to dismiss before the arraignment?
Well, putting aside the fact that that isn't really properly before the court, Your Honor, to answer your question, that all of the rules, first of all, we have the most significant rule, which is 3G, which says it shall go to arraignment after the complaint
Well, it shall
issues.
then arraign the defendant or shall set a time for arraignment.
Right.
And this judge actually had planned to set a time for arraignment and would have heard the motion to dismiss first, but he understood the dictum in the single justice's directive to say he should not do that. So why could he not have set a time for arraignment and said, I'll hear the motion to dismiss now, and if that's allowed, then that will obviate the need for an arraignment and will avoid the need for this young fellow to have a criminal record?
Well, the motion to dismiss under the case law and under Rule 13 would have to be with an affidavit, a motion and an affidavit. And all of that is tied into, all of the rules are really tied in to be triggered by arraignment. And the reason why is because at arraignment, you're setting up the pretrial conferences and the pretrial motions. A motion to dismiss is a pretrial motion, and that would have to be with an affidavit, and that all clearly happens after arraignment. The other thing, is particularly about, because this is a juvenile case, is if you really want to satisfy the mission of the juvenile court, it is to get probation involved and to get these juveniles some services. That's exactly what the purpose of the juvenile court is, to aid, encourage, and supervise these juveniles who are in need of assistance. This is a juvenile who's coming late to school with 5 bags of weed in his pocket. He's clearly not subject to the right type of encouragement, aid, and supervision at home. And the only way he is going to benefit from the services of the juvenile court is if that arraignment happens and then probation gets involved in order to put terms and conditions and put him into programs that will help him. And that is the entire mission of the juvenile court. The amicus brief and my sister point to unadjudicated facts about what the collateral consequences are to a juvenile much further down the road. What's important here is what is going to happen to this juvenile now. And the only way that he is going to get assistance is when probation gets involved and works with their diversion programs, their services. That is the whole reason why the juvenile court is not criminal in
But you're saying then that the DA did this to help him?
Absolutely, Your Honor. There are many instances when the DA goes forward with arraignment, exercises their prosecutorial discretion to go forward with arraignment because this is a juvenile in need of services.
And if the judge says this is not going to help him, this is going to hurt him, the judge has no authority to do that, and the DA determines what is in the best interest of the child as opposed to the child's attorney and the judge?
Well, the judge can. It is a system that has 3 parties involved, 3 branches involved, and the Commonwealth may not agree with the fact that the juvenile needs assistance. And in fact, one of the things that's interesting is immediately when a complaint issues, the docket is created. So there is something out there that indicates that a complaint has issued. But when the arraignment happens, it's when there's the ability to track what's going on. And this, again, is significant in a juvenile case because we need to have a full picture in order to provide this juvenile with the services and the diversionary programs that he needs to have a full picture of exactly what's happening. Maybe a year down the road, that full picture is this is dismissed because of lack of probable cause, that it was arraigned but then dismissed. But it's important for a judge or parties who are trying to help this juvenile in the future to know exactly what has happened. So, for example, if a year down the road the juvenile is caught with a gun or cocaine, that it may be important to know that at this point he had marijuana and he was going down a certain path that maybe programs could have helped. And at that point, they know that there are other programs that they need to put him into. But the diversionary aspect of the juvenile court is critical and, of course, part of the mission and codified in
So
Chapter
if that's
119.
not the case, why not, would a civil citation not trigger any involvement by the juvenile court here?
I'm not sure, Your Honor. The civil citation doesn't happen after arraignment. I don't believe that it does. But I'm not positive whether a civil citation would ever trigger. I can't answer that question. I apologize.
Has the substance been analyzed?
No, not to my knowledge.
We don't know if it is marijuana, or we don't know if it's marijuana that was laced with something.
No, absolutely, Your Honor. And I think it would be difficult to draw that inference on this record, but certainly there's nothing that we know about the substance. And that's part of the reason why, at this stage, the probable cause determination is extremely low.
I take it it's been made by a clerk magistrate,
Yes, Your Honor.
so there's no appeal from that.
No, but interestingly about the clerk magistrate process is there is a lot of discretion that the clerk magistrate has. It's a may issue a criminal complaint, whereas it shall be arraigned. So there is a discretionary part of this case, and it's at the criminal complaint issue. And that didn't happen here. The clerk magistrate had no, had no issue in finding probable cause here. And so at this point,
And the complaint is issued, so there's no appeal to a judge. Don't issue the complaint because there's not probable cause. Complaint is issued
the complaint is issued.
by a
and
magistrate.
And the next step is arraignment by the rules. And when you look at the whole context of the rules, everything, the only rule that says specifically is triggered by arraignment is Rule 36. But everything else, the implication is that it starts at arraignment. The case starts at arraignment with all of the pretrial hearing being scheduled and the pretrial motions can then be triggered. Is it explicit? No, it is not. But when you look at the context of the rules, it is all pointing to the importance of arraignment. The other thing that's important about arraignment is you set the terms and conditions of release. And it's codified in Chapter 119 that the juvenile should not be held for for the shortest amount of time possible.
But if you have a motion to dismiss before the arraignment, which is allowed, then you don't even reach that issue.
Well, Your Honor, you'd have to continue the case. Is he held while he's being continued? And then continuances, again, are all about pretrial. If you look into Rule 10, it's only after it's entered into the trial calendar, which will happen with the arraignment. So again, it's not explicit in Rule 10 that it happens at the arraignment, but I think you can certainly draw inferences in those rules that it's all triggered by arraignment, and that's critical, given to that the rule says shall be arraigned or scheduled to arraign. But in a juvenile case,
They'll set a time for arraignment, which
Yes, but
suggests
in a
that
juvenile
it need not
case-
be done immediately, that you could set a time in the future for
except
that.
then you would be going against the statutory mandate in Chapter 119 that the juvenile be released as quickly as possible. And that if you're continuing it in order to do the motion to dismiss, you wouldn't have that release as quickly as possible. The other thing, if I can just say, you also have the issue of, I apologize, you have to I'm sorry, I lost my thought. But I will point to the fact that the collateral consequences down the line are not as significant. First of all, they're on unadjudicated facts, but they are not as significant as helping this juvenile at this point with the services and
That's
guidance
not
that he
something,
needs.
the record is clear that the judge did not agree with that.
That's true.
The record is quite clear that the judge thought it was a terrible thing.
Right, and this judge has been reversed multiple times by the single justice based on very
Experienced
similar.
juvenile court judge who has an understanding of how the entire process plays out.
Except that he has continually dismissed cases and been reversed by the single justice. And that's part of the reason why he understood that despite his own personal belief, he had to follow what is required by the law.
All right, thank you very much.
Thank you, Your Honors.
Good morning. May it please the court. My name is Emily Cardy, and I represent the juvenile in this case. And I will start with the issue of the dismissal prior to the arraignment, and first state that the only way that the court has the ability to set bail and to assign services for a juvenile is if there is probable cause to believe that that juvenile has committed a crime. Otherwise,
But the judicial officer, the clerk magistrate, has found probable cause. The complaint is issued. There's no right to appeal that.
that's right, But we do have Di Benedetto, and Di Benedetto is the only and appropriate remedy for an inquiry as to whether the probable cause determination was correct or not. And Di Benedetto itself says that a motion to dismiss for a lack of probable cause will lie after the complaint issues. There's no limit on the time frame in Di Benedetto except after the complaint issues. And Rule 13, which governs the pretrial motions, also doesn't limit the timing of a Di Benedetto motion to merely after arraignment. And it simply doesn't make sense to compel someone to come into court to answer for charges for which there is no probable cause. And it certainly doesn't make sense to allow the Commonwealth to leave a permanent footprint on a child's life.
Well, your sister says that the child will benefit from having the case go forward by services being provided.
But the court only is able to provide those services if there's a complaint, a valid complaint against this child. And the determination here was that the complaint was invalid. If the child needs services, one, then a chins could have been brought against the child if a child needs services. A delinquency complaint is not the appropriate action for a child in need of services. That's a chins complaint. And here, a delinquency complaint can only lie if it is valid and only lie if there's probable cause. So if there's probable cause, then the child may, be subject to the services of the court, including probation and that sort of thing. But if there isn't probable cause, then the court has no business imposing services.
Is this limited to the juvenile court context? I understand that there's cases, but is the principle that you're proposing limited to juvenile court cases?
I think it is. I mean, this case is the juvenile court, and I think it is most applicable to the juvenile court. But the idea of compelling someone to come into court and answer for charges for which there is no probable cause to support those charges, I think is applicable to adult court
But
as
probable
well.
cause has been found by a judicial officer, thereby triggering the beginning of this process.
And
The process begins with arraignment, person coming in to answer to the charges. That is the beginning of the process after a complaint is issued.
I would say that the beginning of the prosecutorial process is the application for the complaint.
And it was allowed.
And it was allowed, and the person has a remedy, and that remedy is a Di Benedetto motion. Now, there's an inequity here, because if the person was not arrested, that person could go into court prior to arraignment at the stage of the clerk magistrate making a determination for a clerk's hearing and challenge the sufficiency of the evidence presented and challenge a probable cause determination. And at that point, the clerk magistrate could say, I don't find probable cause, and that arraignment, that charge never goes on that person's record. Here, but if a person is arrested, in contrast, that person never has that opportunity. He or she never has the opportunity to challenge a probable cause determination prior to arraignment. And that's an untenable inequity, particularly in the juvenile court, whose purpose is to avoid the attachment and stigma of criminality.
So are you suggesting that every time a juvenile is arrested and brought into court, a motion for a continuance lies to explore the possibility that there's no probable cause?
I would say that after counsel is appointed, if counsel can look at the complaint against a juvenile and sees that there is not probable cause, then yes, the counsel can ask for a continuance to file a motion to dismiss. It's merely a reordering of the process, or a possible reordering of the process.
How is it different than an appeal of the issuance of a complaint?
Well, I mean, Di Benedetto makes a distinction between a motion to dismiss and the sort of the multiple show cause hearings that happened in Di Benedetto. And my understanding of that is that in a motion to dismiss context, the judge is looking at exactly what and how the clerk magistrate came to the decision that there was probable cause.
But he can't do it. He can't appeal. Haven't we said that there is no appeal from a clerk magistrate's decision to issue a complaint?
You have said that there is no appeal, but you have said that in order to challenge the probable cause determination of a clerk magistrate, the appropriate and only remedy is a motion to dismiss. So the remedy now is a motion to dismiss. What Di Benedetto was preventing...
But don't those motions, don't those pretrial motions under, was it Rule 13?
That's right.
They kick in after the arraignment, and the date is set for a pretrial conference.
Rule 13 actually doesn't give a time frame, except it says that they must lie before a trial date is set. So Rule 13 doesn't specify that the pretrial motions have to come before arraignment. And there actually isn't anything dictating that any of these pretrial motions, if appropriate, couldn't come before arraignment.
So is it now going to be ineffective assistance of counsel for juvenile counsel who's appointed not to seek a continuance to explore the possibility of filing a motion to dismiss for no probable cause?
I would have to say that wouldn't be a per se reason. I mean, obviously, that would have to meet the...
Well, I need
the
time to
Cyprian-
explore this. I need time to investigate, to determine whether there was probable cause.
Here, at least, there was not. It's not an issue of investigation. It's when the clerk magistrate.
I need time to create an argument. I mean, this person was arrested with 5 separately packaged packs of marijuana.
What we think is marijuana, yes.
Yeah, all right. Well, I think we can assume that for probable cause purposes. And there's no smoking paraphernalia. Coming into school, I think certainly there's an inference that he was coming in to distribute his supply to other classmates. I need time to prepare a motion. I need time to sort of do some research. I need time to do all of these things. Is this going to be sort of standard
Well, I mean, first,
before arraignment?
the motion, a proper motion to dismiss in this context doesn't involve additional investigation. It involves looking at the materials that the clerk magistrate used to make their determination. And it's essentially if the clerk magistrate...
I need to analyze this. I need some time to do some research. This
Sure.
obviously involved quite a bit of research because 5 bags of something often is sufficient for probable cause.
And I think that's entirely reasonable to allow the postponement of the arraignment if the Commonwealth has not made a proper showing of probable cause, or even if there's a chance that the Commonwealth has not made a showing of probable cause. And this would be the remedy. It is proper under
The only reason you're saying this is because arraignment then creates a mark that may have collateral consequences? Is that the only reason?
No, I think that it's sort of antithetical to the court system, particularly the juvenile court system, to require someone to come and answer for charges for which the Commonwealth has not a proper basis to bring those charges.
Probable cause has been found by a judicial officer. You come, you plead not guilty, you file a motion to dismiss saying that there was no basis on which to proceed in spite of what the magistrate said. Why isn't that the way business is done, and why shouldn't it be done, except for maybe there's a collateral consequence to arraignment dismissal,
Well,
as opposed to dismissal before arraignment?
the consequences of the creation of an erroneous record, and there is a...
Isn't that a legislative problem?
No, it's not, because unlike for example, in Gavin G, where this court said that that the legislature has created a scheme that takes care of this. This isn't a legislative problem. This
Legislatures could fix it, for sure. About record sealing, I don't know.
The legislature could have said that, well, the legislature has said that juvenile records can be sealed, and we know that they cannot be expunged. But this is properly within the judge's discretion and properly within the role of a juvenile court judge. The record of arraignment, or the record or creation of a delinquency record is only useful in to the extent that the assumptions sort of match up with the assumptions of the record match up with reality.
So the defense counsel could either call witnesses or file affidavits of witnesses that countered the facts on which the police officer relied.
No, that's not the process, respectfully, Justice Spina. That's not the process that we're talking here, because that would be more like the multiple show cause hearings that Di Benedetto rejected. Here, the motion to dismiss, it's almost like a motion to suppress on the four corners of a warrant.
What about, you mean the four corners of the complaint?
Right. So
Did the complaint say that he had 5 bags of marijuana?
Yes, and the judge can also look at the police report as well as being part and parcel to whatever the clerk magistrate used to make his determination that there was probable cause.
Sounds like an appeal of the clerk magistrate's decision is what it really sounds like in sheep's clothing.
It's a Di Benedetto motion, which is a well-established, and this court has said the appropriate remedy and the
We have a
only
motion
remedy.
to dismiss filed before arraignment, but that's okay. Before the case starts.
I would offer that the case starts when the prosecution moves its forces toward prosecuting the juvenile, that the prosecutor takes the first step at prosecuting by going and asking the clerk magistrate, which you have noted is a judicial body, so it is in the judicial system at the point where the complaint is applied for and granted. That is the beginning of this case. That is the point at which the Commonwealth asks a person and compels a person to come to court. And it makes sense in the context of the right to counsel as well, that we would allow the arraignment to happen after a motion, or allow a motion to dismiss after arraignment, because we appoint counsel. And Rule 7 in the reporter's notes, and again, Rule 7 has been revised sort of in the middle of this case, but in the reporter's notes of Rule 7, it says that the preferred practice was to postpone arraignment until such time as the defendant had meaningful opportunity to consult with counsel. And it also says that that one of the reasons that is important is that the counsel may determine whether the charges may be subject to dismissal. So Rule 7 contemplates a real meaningful role for counsel at arraignment. Arraignment is a critical point in the criminal process, and just because it often happens sort of in the same course, the reporter's notes also state that the vital importance of the component parts of arraignment must not be lost in the tedium of repetition so as to foreclose inadvertently the rights of the uninformed defendant.
Now, am I correct that in terms of collateral consequences, it would not matter under Cordy if it was pre-arraignment or post-arraignment, that there would still be a criminal record?
Right, so juveniles are not subject to Cordy.
Right, it's only carry.
The carry.
But I guess under carry, it matters whether you're arraigned. Under Cordy, it matters whether the complaint issues.
I am less familiar with Cordy because it is inapplicable here. My understanding of carry, and the regulations are actually fairly vague as to what constitutes a carry, but the carry is the information that the probation department is sort of mandated to keep pursuant to 276 Section 100. And so as far as carry is concerned, since the arraignment is the first point at which probation is involved in the case, then that would be the creation of the record of the carry.
Okay, and I assume that you agree that if a defense counsel were to ask for a pre-arraignment or time for a pre-arraignment motion, the judge would be permitted to look quickly at the four corners and say denied, that it's a matter of discretion whether a court would allow it.
I would say that it probably, yes, would be a matter of discretion, and here the judge didn't think he had that discretion and therefore declined to exercise that
Now, you
discretion.
didn't bring your own appeal. If we say that a judge is allowed to do this, can it do your client any good?
I think it can. The remedy is, I would ask the court that he be allowed to go back into court as he was, so the record would be, in effect, expunged. And I know that this court has said that juvenile records can't be expunged, but I do know that there has been one instance that this court has expunged a record. So I would ask the court that, in addition to ruling that a judge has this authority, that they would, that you would also provide a remedy for my client, because this judge made it clear that he had hoped and had intended to dismiss the case prior to arraignment.
Could a juvenile bring, if the juvenile doesn't prevail on the motion to dismiss before arraignment, could the juvenile bring another motion to dismiss based on exactly the same grounds later?
I'm not sure what the purpose would be, but I would say
Different
probably
judge.
not a different judge. I mean, that's usually not.
Okay, what about if new material comes up?
Well, then it wouldn't be the sufficiency of the complaint. It would be a different issue. So here we're just talking.
It wouldn't be if there was a certificate analysis that came back that said it wasn't marijuana?
Well, I mean, then there might be grounds to ask that the case be dismissed because it was impossible for the Commonwealth to continue. But then you would have, hopefully the Commonwealth would be assenting to that as well.
Thank you very much.
Thank you.